Og det går an å gjøre det, og det er det neste taler skal få lov til å snakke om. Han kommer fra Nederland og har erfaring med nettopp det å rettsliggjøre klimasaker. Så the floor is yours, Roger Cox.
Well, let's see. This all works. Okay. Good afternoon to you all. Let me first say that it's a privilege to be here today, and I would like to thank the organization for extending an invitation to me and make this all possible. I appreciate it a lot. My name is Roger Cox. I'm an attorney at law from the Netherlands, where I have my own law firm together with my partners in the beautiful city of Maastricht. I'm also the founder of a foundation called the Planet Prosperity Foundation. And this foundation has a statutory aim to help speed up the transformation to a more sustainable society. And from that perspective, we initiate all kinds of projects around the circular economy, in fighting climate change and stuff like that. I'm also the author of this book titled Revolution Justified. It's a translation of an original Dutch book I wrote and subtitled with the words, "Why Only the Law Can Save Us Now." And I wrote this book as a lawyer, but also as a concerned citizen, and also as a father of 2 young children. And it's my opinion that we need nothing short than an energy revolution to protect ourselves from the dangers that energy issues like climate change and other energy issues like oil production decline, for instance, will pose to us and are posing to us already, but will more severely pose to us in the near future. And because markets and politics have shown that they are unable to address these long-term issues, because for a lot of reasons, obviously, but also for one reason, because of the short-term interest that is so inherent in markets and in current-day politics, that we need the legal community, the law and our judicial system to become much more involved in the issue of climate change. And I think that we have a few legal principles that are quite universally, actually, such as the legal principle of the duty of care and the principle of safeguarding human rights, the principle of the precautionary principle, and so on, that can really be effective instruments, I think, and I hope, in helping address, to initiate and create and speed up the energy transition that we need to protect ourselves from future harm. Now, I would like to discuss, well, first of all, the book provided the impetus of the climate proceedings that commenced last year in the Netherlands, because last year, in the beginning of last year, a Dutch NGO called Urgenda, which is an abbreviation of the Urgent Agenda, and 900 Dutch citizens asked me to put my ideas of the book to the test and sue the Dutch government on their behalf. And in these proceedings, we basically asked the court to order our government to reduce greenhouse gas emissions by 40% in 2020 relative to the levels of 1990, and at least a cut in emissions of 25% in 2020. Now, I would like to discuss a few highlights on climate facts that we use in these proceedings and on the legal principles, obviously, that we invoke in these proceedings. Now, these are just highlights. If you want to have more details or more nuanced view, then I would have to refer to the book or to a free download on internet, because the Utrecht Journal of International and European Law had asked me to write a case note on this, which I did in the beginning of this year, and that can be downloaded for free. Let me start then by a few remarks that John Kerry made just recently on his visit. John Kerry, the Foreign Secretary of the United States, recently in his trip to Indonesia, where he was debating climate change and the consequences of climate change in Southeast Asia and also in his own country, the United States, and where he designated climate change as the greatest challenge that we have to face in this century. And he added to this that we must not let a few loud special interest groups of climate deniers take over the climate debate in the media. So this is still happening in the media. I think that there's a lot of naysayers with regard to climate change. And this brings me to the first important point, I think, first important point I would like to make, and why it's so important that we also shift the discussion on climate change from the media to the courtroom, is that we will get a whole different, different debate on climate science. Because the status of IPCC reports from an evidence point of view is unique. And we definitely feel, and I will explain this, that IPCC reports cannot be challenged in the court of law. And the IPCC is, of course, the Intergovernmental Panel on Climate Change, the UN body that issues a report twice every decade on the status of climate change. And these reports consist of 3 volumes. One volume digs into the climate science on the causation of climate change, the next one on the consequences of climate change, and the third one on the methods of addressing climate change through greenhouse gas emission mitigation and through adaptation. Now, why is there this unique status of IPCC reports? Well, firstly, because 195 countries in the world, including the EU, have acknowledged the IPCC reports, because all these countries are signatory states to the UN Climate Convention that was drafted in 1992. And apart from all our countries, also relevant international institutions like the International Monetary Fund, the International Energy Agency, the World Bank, the OECD, and so on, they all rely on IPCC reports. Now, the most important aspect is even that the way that these reports are produced very much mirrors the process of fair hearing and due process, as we know this in the court of law, where the claimants and both the defendants get to say what they want to say. Now, this is the way that IPCC reports are produced, mirrors this process, because the IPCC is open to all scientists, it is open to all governments, and once the first draft of a report is made, and I think it's important to stress that the IPCC does not conduct science research itself, it just looks at the peer-reviewed climate science that is out there in the world and analyzes this and draws conclusions upon this science. But once a first draft of this report is made, it is sent to external scientific panels that then comment on these draft reports. Those comments are taken back and are addressed in the second draft, and the second draft is sent to all 195 countries that are party to the Climate Convention, and each country then distributes it within its own territory to federal agencies, to meteorological institutions, and in our country even to the hardcore climate deniers who also have a position in this process. So then all these comments are taken back once again by the IPCC. These comments are addressed once again, and then this third draft of this report is concluded upon by the 195 countries. So there is no way, all science is viewed in this process. There is no way that you can challenge the findings of these reports. And this is quite important, because I will discuss a few aspects of climate science that are relevant to court cases. Now, this is a quote from a colleague of mine who wrote the book Climate Change, Damage and International Law. No court of law could possibly deviate from IPCC findings, since any expertise put before the court would never be as inclusive as that as inherent in the IPCC. Now, the proof of the pudding is obviously in the eating, but when you look at rulings of courts in relation to climate change, indeed, they follow IPCC findings. To give you one example, and this one is of the High Court of Justice in England, in a case of a certain Mr. Dimmick versus the Department of Education and Skills, because the department was planning to use an inconvenient truth the climate documentary of Al Gore as learning material on schools, and Mr. Dimmick thought that this wasn't a good idea. So he sued the government, this particular department, and said, well, this is just left-wing political propaganda. There is no place in schools for this, and this is not scientifically based. Now, the court ruled otherwise and said this is not propaganda, this is a documentary that is based on science. However, the court concluded that on certain points, Mr. Al Gore deviated from IPCC findings, and the court didn't allow that. The court said, well, you can still use this learning material, but you have to insert a leaflet and make sure that all our children in school understand what the IPCC findings are on these topics that Mr. Gore deviates from. So once again, this makes evident that IPCC rules, so to say, in court. And in our own court case, our government hasn't even tried to deny the facts that the IPCC brings forward. Now, what are these facts? There are a lot of facts. These reports are like 2,000 and 2,500 pages long, so there's a lot of information contained therein, but these are some important facts. We know for 100% sure that after the Industrial Revolution that the Earth is warming, and we know for 100% sure that CO2 has increased due to mankind since the Industrial Revolution, and has increased with 40% in the atmosphere. We know for 95% sure that these two 100% certainties are correlated to one another, that they are connected to one another. So we're 95% sure that man-made CO2 and other greenhouse gases is indeed the cause of warming. And we know for 90% sure that all regions in the world, Norway and Holland included, will be adversely affected with a temperature rise of the average temperature of the Earth, which was 14 degrees pre-industrial times, of 2 degrees. And we also know for 90% sure that the Earth has been warming until today and after the Industrial Revolution with 0.8 degrees. Now, you might think that 0.8 degrees on 14 degrees is not that much, but it is. If you compare your own body temperature of 37 degrees and you add 6% on that, then you have a body temperature of more than 39 degrees, and most of us wouldn't be sitting here, but would be laying in bed. So this is obviously not a very scientific comparison, but it just shows you what a 6% rise can do. And probably if your employer were to ask you to give 6% of your salary back, then you would probably not be very happy. So 6% matters. So what are the consequences of this 0.8 degrees up till today? 75% of the North Pole has been melted in the last 30 years. That is 50% of the surface and 50% of the thickness of the ice, summer ice on the North Pole. Greenland has been, melt was considered there, concluded there in 2012. I don't know what it was in 2013. And some days in July, all over Greenland, there was melt. And we also know that, for instance, that there is an increase in weather extremities on land with a factor of 25 since the 1960s. So in the 1960s, there were extreme heat waves. Extreme means 3 standard deviations outside of the norm. There was only like 0.2 or 0.4% of the land surface that was exposed to these extremities in the 1960s. Now it's 5 to 10% of the land surface in the world that is annually exposed to extreme heat waves that are 3 standard deviations outside the norm. And we know this already causes a lot of influence on food production, on water supplies, on health of people around the world, etc. Now, this is a very, 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 very important fact from a legal perspective also, but also to understand why this is such a huge problem. Because what we are witnessing today in the world, like the melting of the polar ice cap, those are not the results of today's emissions. They are the results of emissions of up to around 1980. So what has been emitted in the world, in the atmosphere on greenhouse gases after 1980 still has to reach its full warming potential, which will take many more decades. But this warming is already unavoidable. So even if we were to stop using all fossil fuels today, there will still be a lot more warming coming. You can compare this if you walked into a very cold house and you would like to warm it. You turn up the thermostat and then your radiator grows warm to the touch almost immediately. But before your house is warmed and all objects in your house are warmed, it could take hours or maybe even days. Now, this inertia is also inherent in the climate system on the Earth, and it takes 30 to 50 years for the Earth to warm after emissions are there. So that's one thing that's already unavoidable. The second thing that's unavoidable is that we also know that we can't stop using fossil fuels tomorrow. So on top of this, we also know that we will be adding a lot more CO2 to the atmosphere in decades to come, because simply put, we are nowhere near of making this energy transformation that is so necessary. Now, the legal relevance of this is that once you start to look at legal principles like the duty of care, for instance, is that you are now in a position to include all the damages that will be done and all the harm that will be done due to this inertia on a later stage in this century, because these damages and harm are very much rooted in our actions and inactions of today. So you can compare it to smoking or the exposure to asbestos, which also has an inertia. You don't, fall on the ground once you start smoking a cigarette. It takes a lot of time before you actually contract the disease. I'm very afraid, by the way, that I won't be keeping this 10-minute mark that you were giving me just yet. Probably I'll go over that by 5 or maybe even 10 minutes, but I hope, my trip from Netherlands to Oslo gives me some room of messing up your schedule. Another important fact is this: in the climate convention that these 195 countries signed and are a party to, states that the basic objective of this convention is to prevent dangerous anthropogenic interference with the climate, so dangerous man-made climate change. And it wasn't up till 2010 that international politics dared to decide what this specific number of dangerous climate change was. And in 2010, in the Cancun agreements, it was decided that the 2 degrees has to be considered as dangerous climate change for humanity. So this is the maximum acceptable risk level for society. Now, keep in mind that 1.5 degrees is already can't be avoided anymore due to the effects that I just discussed. So there's very little room for error here. Now, what does this mean? A dangerous extent of increase of sea level rise, loss of biodiversity, degradation of ecosystems, infection diseases, heat stress, summer smoke, extreme weather events such as heat waves, storms, etc., wildfires, loss of food and water supplies, inhabitability of regions in the world, and migration of people and international security issues due to these migrations of people and problems with food supply and water supply. And another part that is very much related to the 2-degree threshold is that there's a real danger of tipping points, meaning that the climate system could spiral out of control due to, for instance, methane stocks that are now kept underground in the permafrost, but once the permafrost starts to melt in a speedy way, then these greenhouse gases will be added to the atmosphere as well. And once we reach these dangerous tipping points, then it doesn't matter anymore what policies we draft or how much money we would like to throw at this problem, then it's has become an unmanageable problem. So that's also one of the reasons why we consider 2 degrees, or why I should say, why international politics are based on science has agreed that 2 degrees is dangerous. Now, where are we now? We are now on our way to a 4 to 6 degrees temperature rise at the end of this century alone. These are the conclusions not only by the IPCC, but the World Bank, the International Energy Agency, and even respected international operating accountancy firms like PricewaterhouseCoopers have looked into this matter and drafted reports on it. And they're all in agreement that the way we're heading now, we're heading for a world that will on average be warmed with 4 to 6 degrees Celsius. So that provoked the director of the International Monetary Fund at the World Energy the Economic Forum in Davos last year, saying the following: unless we take action on climate change, future generations will be roasted, toasted, fried, and grilled. So we need some female wisdom on this topic. And that's why I think that we have to look at Lady Justice, if you will. We have to look at the law. And the timing for involving the law seems to be perfect because it is now being recognized in both the international political arena and in the legal realm that climate change is indeed a threat to the infringement of human rights everywhere in the world. Now, to give you a quote from the United Nations Cancun agreements that I was referring to of 2010, and I quote, "Climate change represents an urgent and potentially irreversible threat to human societies, and climate change-related impacts have a range of implications, both direct and indirect, for the effective enjoyment of human rights, inter alia, the right to life." Now, this connection between the right to life and climate change has also already been made by the European Court of Justice, because in one of its rulings, the European Court stated that emissions of greenhouse gases are amongst the main causes of climate change, and it should be noted that climate policy is also designed to protect the health and life of humans. So our courts have already accepted the climate science, I said that before, and our courts have also accepted that climate change is not just about drowning polar bears in the Arctic, but that it will have severe consequences for humanity. And the US Supreme Court has even added to this that because of the severity of the consequences of climate change for humanity, that states, our governments, can no longer excuse themselves from doing nothing just by pointing to other states and claiming that as long as other states don't mitigate their CO2 reductions, then we shouldn't have to do it either. The Supreme Court in the United States didn't buy that and ruled that a reduction in US domestic emissions would slow the pace of global emission increases, no matter what happens elsewhere in the world. So no matter what happens in India or China or any other country in the world, once we start to reduce our own greenhouse gases, it will slow the pace of global warming in any way. And that this will give us just more time to address the issue. And this individual responsibility of states is also one of the principles laid down in the Climate Treaty, where each state has accepted the precautionary principle as one of the principles that should be applied as of 1992. Now, this is a very important case, so I'm going to dig in a little bit deeper on it, because in this case, Massachusetts had asked, and a few other states as well in the United States and a few other organizations, had asked the Environmental Protection Agency, which is the federal agency concerned with the protection of the environment in the US, they had asked them to make a ruling that CO2 and other greenhouse gases were to be considered as an air pollutant under the Clean Air Act in the United States. And the Environmental Protection Agency refused to do it and had a lot of defenses also in court. For one thing, they said that it didn't matter what they did because of the emissions in China and India. We've addressed that. But other reasons were that this was a political item, that there was no place for the Environmental Protection Agency to rule on something that has so much so much consequences, and is so complicated. It's connected to geopolitics. It is connected to our current status of our economy, etc., etc. And other defenses were that we're not sure yet about climate science, and we need to study climate science more, and that's also why we can't rule on it. Defenses like that. These were all overruled by the US Supreme Court, because these are a few of the considerations that the Supreme Court made, because harms associated with climate change are serious and well recognized. So again, the science is clear for the judiciary. And the risk of catastrophic harm, though remote, is nevertheless real. So it may take some time due to the inertia that we talked about, but there's a real risk of catastrophic harm for our society. And also the Supreme Court ruled that EPA's steadfast refusal to regulate greenhouse gas emissions present a risk of harm to Massachusetts that is both actual and imminent. So our inaction is a danger, it has become a danger in itself. Now that is what this is the basic information that you need to understand what we're doing in the Netherlands and what could be done in other European countries as well. Because one of the principles that we invoke in these climate proceedings is the legal duty of care. Now, what does a duty of care in essence mean? It's also sometimes named the reasonable man standard, is that you compare the conduct, the factual conduct of the defendant, and compare it to the conduct that you would expect from an average, careful person, duly weighing risk and care in the given circumstances. Now, where the defendant's conduct doesn't meet this standard, then he is breaching a duty of care, and then negligence can be established. Now, universally, there are a sort of criteria that you need to meet before you can conclude that there is a breach of duty of care. And probably in Norway, these criteria will be more or less the same. In Dutch, they are the following. How apparent is the danger? Now, the danger is clear. It's defined universally by not only science, but by our politicians as well. So the danger is apparent. The second question is, how great is the chance that the danger will manifest itself? We are now on a trajectory of 4 to 6 degrees at the end of the century. So there's a real risk here, a very real risk, that we will cross the threshold of 2 degrees. So there's great danger. How serious is this danger? Now, as the Supreme Court already concluded, there's a real risk of catastrophic harm at the end of the day. And then the question is, and this is very much related to, as I understand, the discussion that you're having today with regard to your constitution, is the fourth question, is the measure of responsibility of the defendant, in this case the Dutch government or any other government, towards the claimant. And this is very much based on constitutional obligations. Now, the Dutch government has a constitutional obligation to protect the habitability of the country and to protect or to protect the living environment in our country, etc. So there is an obligation for states and responsibilities for states to act. And this is also the same in international law and also the same with regard to the European Convention of Human Rights, to which Norway is also a member, because once pollution or human rights infringement takes place within your territory as a state, you have to address it. So you cannot allow human rights infringement in your own state. Now, the fifth question would be, how objectionable is it to take preventive measures? So does it cost a lot of money? Are there any alternatives for what you're doing, etc.? Now, this is probably the topic that we will discuss the most in our court case in the Netherlands. But it's our opinion that the implementation of energy efficiency and renewable energy or other methods like carbon capture and storage or whatever are technologies that can be implemented and that will have benefits on the long term. So once you compare this to the dangers that we all face with regard to dangerous climate change, we think that there is no objection to implement these measures. Now, the same argument is actually with regard to human rights infringement. A 4 to 6 degrees world will have huge human rights infringements all over the world and in Western nations as well. And then the question would be, is there a legal justification for allowing this? This threat is already enough to incorporate and to invoke human rights. Well, the right to life, for instance, is a right that can hardly be infringed, but other rights can be infringed a little bit. But you can only infringe them once there is a law that gives you, as a state, that gives you the opportunity to do so. That's one thing. And the other thing would be that the infringement should be necessary, and I quote, in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of the disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others. And this is paragraph 2 of Article 8 of the European Convention on Human Rights. So this will also be a discussion within our court case, because our government says that due to economic reasons, there is this justification for doing what they're doing. We think that's not the case. Being dependent on fossil fuels like we are now does not only lead to the problem of climate change, but has other issues as well, such as the oil decline problem, the dependence on Middle Eastern states, etc., etc. So we really think that going on the path of renewable energy and energy efficiency is in fact the only way forward to protect democratic society and all other things. Now, I won't go into this because that will take too much of time. In essence, the lawsuit in the Netherlands, the plaintiffs are one NGO and 900 Dutch citizens. The defendant is the Dutch government. The legal grounds that we invoke are the duty of care and the threat of human rights infringement. And the claim is to order government to do its share, to stay below. That's something I should have explained, but there's no time for this. Should stay below 450 parts per million CO2. And this means, in effect, a 40% reduction of CO2 in 2020 relative to 1990 levels, or a minimum of 25%. One more remark. Let's remember that in the 1950s, it were the courts of law that declared that the school segregation system in the United States was unconstitutional. There wasn't any political party at that point claiming that we should get rid of school segregation system. It were because of a few black people that dared to go to court and ask their courts to conclude that there's a human rights infringement going on, that society and politics had to change in America. And we're all glad that it happened. And my point would be that if courts can change society for the better, then this might be the time to start asking our courts to also intervene in the issue of climate change, since our governments and markets are not really up to the task at this point. That would be my concluding remark.
Thank you so much, Roger.